219 to 2221.
May it please the Court, my name is Paul Reefan. I represent the Police Pension Fund in this case. Your Honor, may I reserve 3 minutes?
3 minutes? Yeah.
As respondent in Maldonado and reply in Macri?
Yes. 3 minutes. Go ahead.
Okay. It's our position that there is clearly rational, fact-based medical evidence to support the determination of the medical board in each of these cases. Not conjectural, not speculative, not unbased suspicion. Where credible evidence exists to rebut the presumption, the determination whether or not to credit the medical experts is up to the trustees themselves.
But how do you define credible evidence?
Credible evidence, as this Court determined in Meyer and in Borenstein, is rational, fact-based medical evidence. In other words,
what about the literature that they referred to?
No decision of this Court or any court has required the medical board to turn to literature. The legislature has created a medical board of 3 doctors.
You say the medical board's opinion is in itself credible evidence?
If it is rational, if it is supported.
Well, then why do they bother to pass the bill shifting the burden? If your board's own opinion.
Their opinion has to be fact-based. They have to look at medical evidence.
In Macri, what are the facts?
In Macri, what the medical board said, in July 2002, he was diagnosed with stage 4 pulmonary lung cancer, which had spread such an extent that it created a fairly large tumor in his sacrum. The medical board is saying, based on their experience.
Based on literature, that's what they said.
No, that's based on in their initial report, they said based on their experience.
So if the police board doctor, or the medical board, says, I've looked at this situation, and based on my experience, it doesn't look like the World Trade Center caused it, that's enough.
It's enough based upon looking at the medical evidence that was before them.
Yes. They look at the medical evidence, and they're doctors, and they say, without explaining exactly why, they say, no, it doesn't happen this way.
What they were saying in this case is simply put, lung cancer does not spread that quickly.
Right. I understand that they're saying that. You're saying that their word stating that conclusion is enough.
Yes, Your Honor. Yes.
Even in the face of medical testimonies saying that it's a significantly contributing factor?
There was nothing saying that it was a significantly contributing factor. The experts for Mr. Macri were not saying that it preexisted and this aggravated it.
He had a chest X-ray on that same day because he was getting debris. There was a chest X-ray,
but that X-ray was not presented to the medical board. They never saw the films. It was on 9/11. We don't know.
Wait, this is a case in which you have the burden of proof.
Yes, but if we're going to rely on a chest X-ray, it was not before the medical board at all. I don't think that's relevant evidence. It was done in the chaos.
Okay, but you can't win the case just by knocking down the petitioner's evidence.
No, we're not trying to do that.
What is your evidence? What is the basis? Just that you say that's what it is?
It wasn't saying that's what it is.
In your medical opinion, that's what it is?
It was the medical opinion of the physicians of the medical board, given the rate at which cancer spreads, that this individual could not have, based on the exposure of
even when there's other testimony that says it's a plausible relationship, you say?
We're saying if there is credible evidence, rational, medical, fact-based evidence.
And define credible evidence?
Define credit is rational, fact-based medical evidence. In other words, the Board of Trustees.
How do we know it's fact? I mean, on your theory, why can't the medical board turn down every claim? Why can't they say, we have looked carefully at the medical evidence, we are very experienced. Let me finish the question. We have looked carefully at the medical evidence, we are experienced doctors. In our opinion, science doesn't work that way. We reject the claim. Is there a case in which that would not work?
Yes. If there is, it's simply they didn't do that in this case. They looked at
then take it as a hypothetical. Would it work?
You have to look at the facts of each case.
Well, what facts in this case are so different from what I just told you?
They looked at Mr. Macri's medical condition, which was in July 2002, 9 months after exposure to 9/11. He had stage 4, the final stage of cancer.
And they say you can't get through 4 stages in 9 months. But how is anyone supposed to know
Well, that's up to the trustees then. The individuals.
But if they don't provide some basis to justify their medical board determination, how are the courts supposed to evaluate?
Well, you know, the approach that they did, one of the things that they have done is almost the same as what the federal government has done under the Federal 9/11 Act, which is they have established criteria for compensation under the 9/11 Act, and one of the criteria are the nature of the symptoms and the temporal sequence.
Are those criteria in the record?
Yes, they are in the Federal Register.
If the medical testimony was so clear here, then why aren't all three of these cases a split in the trustees?
I can't explain why the representatives of the police almost always vote in these cases.
Well, then that means we're going to end up with a lot of these Article 78s, correct? So
well,
if there's no justification from the medical board, I go back to my question, how are the courts supposed to evaluate this?
The courts do have a lot of these cases. And I want to point out.
Suppose that the cancer here had been stage 2 rather than stage 4, and the medical board had said, in our opinion, stage 2 can't happen that fast. How would we know whether they were making sense
it's
or not?
In all due respect, I don't think it's for the courts. It's for the trustees to make that determination.
Counsel, do you have to lay out data to support your position? Or when you refer to data, do you have to say what it is?
I don't think they're required. I don't think they are required.
And in Macri's case, what did you do?
In what respect?
What data did you refer to?
The medical board reviewed his medical record.
Well, I thought there was reference to substantial medical literature and copious data.
Yes, they didn't. It's true they didn't refer to it. It's our position that they didn't have to. And I want to point out that.
But they did. They did refer to that as a basis.
They referred to it, but they didn't.
Is there a reason they've never identified it?
I don't know.
But if you refer to it, isn't there a requirement that...
I want to point...
I mean, it's just like throwing out, saying, we're right, and there's data that supports us. Isn't that all you're saying?
But you can't see it.
But let me say also, Macri's doctors did not disagree with the doubling time at all. That was not the issue. They didn't, in their reports, and they had access to the reports of the medical board, they didn't say the medical board was wrong in terms of the doubling time.
I guess what I'm saying is Macri, absent something from your client, Macri could win this case without producing anything except the presumption.
That's correct.
And I'm still having trouble with what you have, other than to rebut the presumption, other than I'm a doctor, I looked at it, I don't think it works.
That's the responsibility of the medical board, to make an informed medical decision.
And they don't have to explain it so that some neutral third party can see whether it makes sense or not?
What they said was, given the advanced state of cancer in July 2002, they believed to a high degree of medical certainty it could not have been caused by 9/11.
And they could, but what would stop them, other than their consciences, from making that statement in every case, just substituting whatever the date was?
Because it wouldn't work. It wouldn't work. They could not say medically. I'm not sure I understand.
I guess assume he's cynical for a moment. Assume you've got a doctor who would say anything. I know there are no such doctors, but assume you've got a doctor who will say anything. Why can't that doctor win every case for you by saying this in my medical opinion to a high degree of certainty this was not caused by the World Trade Center?
It would not be a rational fact-based.
How are we supposed to know that?
It's
particularly in the face of a presumption the other way.
It seems that what's happened here has totally nullified the presumption because you're putting the burden of causation on the patient as opposed to...
No, I don't think so. The burden was still with the police pension fund, and the medical board examined him. They took into account his experts' responses, and what they were saying based upon that is that in their professional experience, they do say, given this copious...
So the rule is if you say that their medical evidence is not credible, that makes you credible.
No, it's not there. It's whether or not the medical board's recommendation is credible based upon their experience.
I think I've asked...
So then there's no presumption because any time the medical board issues a determination, we have to accept that as sufficient evidence to eliminate the presumption.
No, it's a question whether a trustee could accept that.
But how is a trustee or a judge supposed to tell whether the medical opinion is credible or not credible?
But in this case, the question was the cancer spread. The cancer could not have spread so quickly. They're looking at the experts that.
Now, I don't have the slightest idea whether it's 100% true or 100% false. What in this record, other than the fact that these people are doctors, tells me?
You look at what the petitioner, what the officer's experts say, and we find out in this situation they don't disagree with the medical board on the spread, the doubling time, the rate of spread. What they say is an entirely different cancer. It's a especially aggressive
Do you think
cancer.
what your position does really creates a presumption the other way?
No, Your Honor, we don't. We don't think what we've done here is any different than what the courts have sustained in
the very little time you have left, could you just give me an idea of what you think are the factual differences among the three? We've been talking all about Macri, but tell us about Bitchatchi and Maldonado quickly.
Well, not Maldonado, I'm responding.
I'm sorry. I'll let you talk about it.
Bitchatchi had a lengthy history of colitis. Rectal cancer is clearly.
Yes, my real question is, do you think, would you say that Macri and Bitchatchi are essentially identical cases, or is one stronger than the other for you?
Well, if anything, clearly Bitchatchi is a stronger case for us. The person had a risk factor for rectal cancer. And the medical board, again, said given the size of the tumor.
Wasn't there about 20 years, though, that he had the surgery and wasn't he cancer-free for a couple decades?
The irony is, in the Bitchatchi case, the medical board actually cited literature that said it can be as long as 25 years, and that was rejected by the court.
Well, but I guess my problem with Bitchatchi is I understand that there's I can see that there would be credible evidence that her previous ulcerative colitis had something to do with the cancer, but as I understand, her whole theory was, I was at risk for the cancer, but the World Trade Center triggered it. What credible evidence in the record refutes that?
Again, what the medical board said is given the size of the tumor, in October 2002, given the size of the tumor, they again felt.
So this is Macri all over again. We've looked at it. Mother Nature doesn't work that way.
You don't think that that's conclusory on your part to just say that, we don't think so?
It's not conclusory. I don't think they were cavalier about this.
Without more?
I don't think they were cavalier about this. They're saying in their professional experience.
Doesn't it seem cavalier to you to announce that there's data and not tell anyone what it is?
I don't think in that case that the data, that was the issue, because the experts who responded to the medical board never challenged that data. They never said the doubling time was incorrect. It is a red herring. They said this was a different cancer. Not that the medical board was wrong in determining what the doubling time was.
Do you draw a distinction between competent evidence and credible evidence?
I think competent, credible evidence is competent evidence to rebut the
Okay, Counsel. You'll have rebuttal. Counsel.
Good afternoon, Your Honors. May it please the Court. Chet, Lukaszewski for Petitioner Appellant Maldonado. 3 minutes in reply.
3 minutes of your 8, okay?
Yes, please.
Go ahead.
Thank you, Your Honor. Your Honors, I think you've hit the nail on the head with regard to a conclusory opinion can be put forth in every single World Trade Center case if the decisions at issue herein.
But your guy, your client actually had symptoms before September 11. Doesn't that distinguish him from the others?
The secondary arguments, I believe, in the other cases, Your Honor, are even if it can't be established that the cancer was non-existent on 9/11, there's a strong possibility supported by the medical literature in every case, even supported by the NIOSH study, which has been submitted by the city in every case, that the toxins could exacerbate a pre-existing cancer.
But he had this tightness in his spine, didn't quite yet feel the lump. Maybe it was growing. You say that it could have been exacerbated by his work at the World Trade Center site?
I say it based on the report of his oncologist, who's a renowned expert who provided medical theory.
But what did the oncologist exactly say?
He said the theory of angiogenesis was the scientific explanation for why the growth was so extreme and so great.
Could the pre-existing condition, the factual scenario here, basically rebut the presumption, statutory presumption?
The language of the law calls for the disability, Your Honor. So if a pre-existing condition, particularly under the Tobin case, existed but was not disabling, then the basic principles established in Tobin would apply.
Well, that's what I wondered about that. I mean, it's this, you're really arguing a Tobin issue, aren't you? And isn't the burden, the presumption is gone? Or
I don't see why they wouldn't operate hand in hand, Your Honor. And in my briefs, I provided the examples of you could have minor asthma, you could have minor GERD, you could have minor depression, you could take medication, you could pre-disclose, and you could not miss a single day of work your entire career.
Well,
then all of a sudden you're a first responder, you're exposed to the toxicity, and if you're to apply later, then all of a sudden you don't get the burden, then it makes the role of the medical board even easier.
You have the burden then of showing that, though, don't you, that the exposure exacerbated it. It's not the same thing as the presumption in your favor. Or am I missing something?
It's a presumption of contribution, of a causal connection, that there was an exacerbation. Yes, no, I agree that I have the burden to – I'm not claiming that there wasn't a pre-existing condition. My doctor –
on your theory, can anyone who had cancer before September 11, and it gets worse after September 11, as cancers, I guess, have a way of doing, can he come in and say, by virtue of the presumption, the worsening of my condition is due to 9/11, now you disprove it?
No, Your Honor. I think the law discusses the fact with regard to medical literature. If there's medical literature that an officer had stage 3 or stage 4 cancer prior,
so I guess if I understand you right, you're conceding that with somebody who already has a condition, he can't just come in and rest on the presumption. He has to have some other proof.
Absolutely, Your Honor. I think that's where the facts, especially in this case, are very relevant. Like I said, if my client or if any applicant was disclosing a major form of cancer that regardless had 9/11 happened or not 9/11 happened, it would have been deemed disabling. To come forward after that and say, well, I'm disabled because I was exposed, that's not going to pass the rational or fact-based test.
So if I'm understanding you, this is not a case about the presumption. This is just a case about what is or isn't supported by the record.
It's also a case about the presumption, Your Honor, because in this case, the conclusory opinion of the medical board, based on no data, based on no explanation of why my client's top oncologist, who explained that this was rapid growth.
Okay, but you don't need a presumption for that. I mean, if their proof is as bad as you say, you win without the presumption.
And with the presumption, I'm hoping that's even more evidence of the wrongdoing in this case. And again, it boils down to
you can say you're relying on the presumption even though it's pre-existing.
I'm relying on the presumption because I can't prove, I have no litmus test, I have no MRI, I have no X-ray, that toxins fuel cancer. It's simply a medical theory that the experts who have studied this subject have formulated. It's the whole basis. And in every journal article and in every case, even by the first department.
What's speculative and what's, based on medical evidence? Can medical evidence be speculative?
I think medical evidence in a case like this with cancer is a scientific theory that while there's no proof positive, like angiogenesis, like having an oncologist from Mount Sinai say, I've never seen growth like this. I've never seen something go from this to this in 58 days,
well, so
and then spread from soft tissue to bone and lung.
What if it had grown more, what if it had been clearly pre-existing and it had grown more slowly? Then are you saying then?
Then, again, with the language of the presumptive bill, competent evidence, the medical board could say, no, we have the New England Journal of Medical article that says angiogenesis causes such growth and not such growth. Or they could come and say the cancer textbook says that the progression of 10 months on a tumor is standard and was unaffected. That's not the facts of this case. We have a small lump that went to the size of a softball and jumped from soft tissue to bone and lung, which a top oncologist, this isn't me, this is an oncologist saying, I haven't seen this.
Okay, Counselor. You have some rebuttal.
Thank you, Your Honor.
Counselor?
May it please the Court, I'd like to try to offer a simple syllogism that I think might come after Mrs. Mackley that I hope can be helpful. One, I begin with the premise that the legislature must have intended the World Trade Center presumption to mean something, and that's why the city opposed it. Two, the least the presumption can mean is that an ipsa dixit from the city's doctors is not enough to rebut the presumption. And if that's so, two corollaries necessarily follow. One, it's not enough to point to medical literature and data that won't be identified and can't be contested. And that's this case, it's Bitchatchi, it's Maldonado, and it's matter of dement, which I understand is a leave application currently pending before this Court.
What do they need
All
to do?
those cases.
What do they need to do to rebut the presumption? The city.
I'm not a physician, Your Honor, of course, appreciate, but they cannot rely on completely conclusory data that they don't identify.
If they attach data that met their description, would that do it?
That would be it's a different case if they articulated what the doubling times are, identified the literature, so they could be contested. These are in effect adversarial proceedings. Mrs. Macri couldn't contest a doubling time literature that was never identified. It wasn't even stated that it included.
Why do you say, I mean, maybe it isn't your problem. Why do you say that? I think I understand why you think your description fits Macri and Bitchatchi. Why Maldonado?
Because in Maldonado, too, there was a reference in Maldonado to the size of the growth. And it's just, again, ipsa dixit. It couldn't have grown, the growth of that is just inconsistent with anything.
Why isn't the pre-existence of the existence of symptoms before September 11? And
that's a different question. To the extent that my colleague here, Mr. Lukaszewski, I'm not sure if I understood him, took the position that the presumption Tobin presumption, the World Trade Center presumption does not apply to Tobin causation. That's our second argument. I respectfully disagree with him. That is, I think, dead wrong if that's what his position is. The presumption does apply. There is no authority that does not apply. Tobin is the fabric of the law in this state. And this Court has recognized that causation includes aggravating a condition.
Okay, but doesn't there come a point? I mean, suppose a guy has cancer before September 11 and he shows up on September 12 with some hideous stage 4 cancer. Can he use the presumption to say it was September 11 and did it, or does there come a point when it's just ridiculous?
Well, the answer is he certainly can use the presumption. And in the case that Your Honor identified, I don't think that there's going to be too much trouble for the medical board to come forward with non-conclusory ipsa dixit that just simply says, no, trust us. That's not right. That's what the responders got.
So how would you propose that we tell the city what it is they have to present to overcome the presumption in whatever hypothetical case?
I don't think that Your Honors can do more than you already have, which is laid out in matter of Meyer, what the standard for credible evidence is. Let's just continue with the assumption for the purpose of this appeal that credible evidence and competent evidence are the same. Your Honors have made clear what that is.
So if they cite studies, that's sufficient on their side. And then the applicant for the retirement benefits has to contest that study?
They can't just cite studies like they did here, say don't even identify and refer to doubling times and not tell you whether the doubling times is the average.
But if they cite studies that do in fact say what they say, that would be good enough.
It could be. It could be. Suppose, Your Honor, they cited a study that showed 40% of the cases of pulmonary cancers like this grew to 2 centimeters by 2 centimeters by 0.9 centimeters in less than 9 months. That's a hard case. I'm not sure I know what the answer is to that one. But we don't know here.
You would identify those studies. That's
right. You can't know. And it's such an irony. My adversary here a moment ago was talking about the X-ray. And he was saying with respect to the X-ray, well, the X-ray was never brought in. It was never produced. And in fact, what it says in his brief, in the reply brief, is that the X-ray film was never, quote, never produced and could never be examined or verified. Now, that's our point.
You have the same disability because obviously you can't cite.
Right. I mean, this double standard couldn't be more palpable. Mm-hmm. It's okay for the city to object that the X-ray film couldn't be examined or verified, but it's okay for the city that bears the burden to rely on data that can't be examined or verified? That can't be right. That can't be what the legislature intended in enacting this statute. So, but I want to continue with the Tobin analysis. That is our second argument. And I just want to say, it is the fabric of the law. There is not a shred of support in the statute for the proposition that the legislature inexplicably intended to deny 9/11 responders the same causation benefit of the Tobin rule to them. They don't get it. All the other police officers in garden variety accidents, they get the benefit. And the 9/11 responders who faced tremendous medical uncertainty about what caused that, what's going to cause it, they don't get it? That makes no sense. My adversary's sole argument is based on Section 2, subsection 36, A, Romanet 3 of the statute. And all that says, it's part of the 2008 chapter amendments, it says that it arguably conditions the presumption, and I stress arguably because there are sophisticated issues here, but it arguably conditions the presumption on the appearance in medical records prior to September 25th of evidence of the condition. That's not my case, right? And that's not even the Maldonado case. That evidence doesn't come up until later. Again, just quickly with 1 second, with respect to what this Court has already said. This Court has already said time and again in matter of Meyer, credible evidence can't be conclusive. It must be evidentiary in nature. It's evidence that proceeds from a credible source. An anonymous source is a credible source. And just as importantly, in this case, the Court can't have any idea whether the medical board's no causation proposition is reasonable.
Okay, good.
Thank you.
Counsel. Counsel, rebuttal.
So with regard to the question of pre-existing condition, the Retirement and Social Security Law, which created the presumption in the World Trade Center, Section 2, Subdivision 36, makes it clear that if there was evidence in any pre-employment physical or any evidence in the medical records indicating the individual had cancer before 9/11, there is no presumption.
You're saying that you're not saying that his clients can't take advantage of Tobin, but you're saying that as far as Tobin is concerned, they're on no better footing than if the law had never been passed.
Yes, that is correct. And more importantly, in terms of Macri, his experts never claimed pre-existing condition. Again, I come back to the fact that they were saying that this was a different cancer. This is a more aggressive cancer. None of his doctors said the cancer pre-existed, and that's a critical factor, at least in terms of the Tobin analysis in the Macri case. With regard
Counsel, what about the issue of the data? That do you contest the fact that the board can't just cite data and not say what it is and yet have credibility?
Yes, Your Honor, there is no case.
So your case is no stronger or weaker than if they have not cited data at all, but that's worthless, right?
If they had not cited data at all, which is what...
No, but what I'm saying is that's worthless to say there's data out there without saying...
No, I think the Court has never required the medical boards to cite literature.
I know, but my question is that what they did there was worthless, right? Citing data but not saying what it is.
No, what they were doing, they were saying in our professional experience, this cancer could not have spread so quickly.
Yeah, so the answer is it's worthless.
By the way, this is
yes,
supported.
But that's a throwaway.
It's not a throwaway because again, his experts did not challenge that. That was not an issue.
Didn't challenge what they didn't know what it was.
But they didn't challenge. They did not say that the doubling time analysis, the whole basis of what the medical board did was wrong. They said this was a different type of cancer. It's more aggressive than the normal type. So the question of the doubling time was not even an issue.
How do you challenge data or studies you haven't seen?
They weren't challenging the data. That's
well, you're
my
saying
point.
it, but that's not true. I mean, you're saying, well, doubling time doesn't work, and they're saying it does work. You're just not using the right data. And you're saying, well, what we say is absolutely true, so you must have a different.
What I'm trying to say, Your Honor, is that his experts didn't question the doubling time analysis.
Right. They didn't dispute that 1 and 1 equals 2. What they're saying is that's not the issue. 1 and 1 equals 2. In this case, we've got a 2 plus 2 equals 4 case.
And our position.
And you don't have any basis for disputing our 2 plus 2 equals 4 case.
Yes, and what the medical board says, yes, in our position, in our view, to a high degree of medical certainty, given the normal clinical course of cancer and its advanced stage.
You're saying all cancers are 1 and 1 plus 2, and they're saying ours is a 2 plus 2 equals 4, and you can interrupt me anytime.
And the medical board, in the end, was saying that's for the trustees to decide which of the experts to credit.
Okay, Counsel, thanks. Counsel Rebecca?
Your Honor, just 2 quick points, if you would. I hope my colleague misheard me. I hope I was clear to the Court that I emphatically feel Tobin does apply in conjunction with the WTC presumption. Second, with regard to the Board of Trustees, and I will get Your Honors the site, I don't know it off the top of my head, the way the Board of Trustees is formed is that it's a board which consists of 12 votes. 6 go to the quote-unquote city side, 6 go to the quote-unquote union side. Throughout the history of these cases.
Tie votes are not unheard of.
Tie votes, thanks to the Chet case, and again, I'll get you the site, go to the city side. So to say that to convince a trustee.
Overwhelmingly, in most of the cases, 6-6?
Always. 99 out of 100. I apologize. I know of 1 case. So to say
Does anybody do any self-examination of why they're sitting there then? I mean,
Your Honor, from your mouth to the board, I've tried to raise that, but it seems to.
Let me go back to how Tobin works with the presumption. You say Tobin certainly applies. On the other hand, it can't mean that every time somebody has a condition that gets worse after September 11th, it's presumed to be due to the exposure? Is that what it means?
No, Your Honor, that would be a case where the competent evidence has to be put forth. And I think with regard to what
just as a matter of logic, I think is what Judge Smith is at. How can that be? How is that consistent with the idea that if you accept the idea that something that's pre-existing is not covered by the World Trade Center presumption, but is covered by the Tobin presumption argument, don't they have to work together that way?
They do, Your Honor. In terms of the Tobin presumption, generally the Tobin presumption pre-9/11 applied to if you came on the job with a back injury, you disclosed it, you were in a car crash, and then you had a spinal disability. It prevents the medical board from saying, well, you had a pre-existing condition, so we're not giving you the higher level of disability. Well, it was exacerbated by this event. In this case, and without even cancer, if you had mild asthma, but you never missed a day of work, if you had mild gastrointestinal problems, if you had a mild psychological problem, and then this event where there was recognized toxicity with regard to the lungs and the stomach and psychological effects, now you have a severe form of the disorder.
But you do have to come forward with something. Even in a World Trade Center case, if it's a Tobin case, you have to come forward with something that says there's a reason to connect the worsening to the World Trade Center.
Absolutely, Your Honor. And that's why I believe, especially for my case that I'm here to argue, he did come forth. He came forth with a top oncologist who said this is rare, I've never seen it, and the medical theory of angiogenesis is what could have caused this with the toxicity.
Would that not have been a sufficient claim even before they passed the new law?
Do you want my opinion? Because in my opinion, it wouldn't have sufficed, because it didn't suffice with the law. But should it have sufficed? Should it have sufficed? Possibly. But with the law, I think it certainly does, Your Honor.
Okay. Thank you all. Appreciate it.